Okay, are we live now?
Wait 1 second.
Okay.
We're now live.
Okay, thank you very much. And welcome to the Family Law Juvenile Law Subcommittee for today's meeting, which is a meeting where we're going to talk about just one bill, and that's HB 931. And one of the things I think I want to just start off with is this is Delegate Eric Hand's bill, and it is to provide a 24-hour notice to parents of children who are in childcare situations. Whenever there's a report of child abuse or neglect, those parents will get a notice, and it should be, I think the requirement is that it just be in written format. Is there any discussion on this bill? Any concerns, any questions that folks may have regarding this? One of the things that I also, go ahead, I'm sorry.
Sorry, I don't want to interrupt you. I was just trying to raise my hand. I don't know if you can see it. So whenever
I didn't, thank you very much, Delegate Shetty. Go ahead.
Oh, I feel bad interrupting you, Madam Chair.
No, it's okay. Go ahead, because I didn't see my hand up.
I was just gonna inquire as to what currently is required by law, if anything. I fully support parents getting this type of notice. I mean, thinking from my exposure to the school system at this point, like my son, while he's been in preschool, whenever he has fallen on the playground or whatever, like we get a call and we get a written notice, as soon as essentially like whatever the condition is has stabilized. So I imagine that, I just didn't know if that was like already a requirement or if that's something that like his school just happens to do. And so, so that's my question. What's currently required?
Well, according to the Maryland Department of Human Services, there is a requirement, and that requirement is to contact, it looks like to contact parents. I think there's like a, let me just read this really quickly. Looks like there's a requirement to contact the parents. Well, actually what they do obviously is they contact the various authorities. And I think that's like a 48-hour requirement that they do that. And so before they would even, go out to contact a parent or even anybody else, of course, the child care providing entity needs to contact, and let me just make sure of who they are to notify. Looks like they have to notify the state superintendent of schools within 48 hours if a report of suspected abuse is made. And then there is, I believe, some investigation pieces to that. And so, in fact, this was raised with the Department of Human Services, their concern about having to contact or child care providers contacting parents within 24 hours, because what that does is it obviously conflicts with the requirement that the child care provider must contact the state superintendent of schools, the local Department of Social Services. All of those people have to be contacted within 48 hours. And so that they can then start an investigation, because of course you don't want to start a disruption within the school because now you contacted people earlier with a possible complaint that maybe has not even been substantiated yet. So that is one of the concerns, I think, from the Department of Human Services. But it does look like there is a requirement to contact the authorities, within 48 hours of a possible child abuse or child neglect situation.
So no requirement to notify the parents of the child currently, but just a requirement to notify external law enforcement investigatory powers.
Yeah, that's what it looks like. And no requirement to immediately contact the parents that are that have children in that school. So yes, that is what it is. And remember, it is the child abuse or child neglect of a child that's in that child care providers' care and custody. So let's see if there's anything else. Yeah, that's it. A written report to the local department is required no later than 48 hours after the contact, examination, or treatment that caused the worker to believe that a child has been subjected to abuse or neglect. Lauren, is there anything else that I may be missing?
No, I think you explained it very well. And to Delegate Shetty's excellent question, it does look like the reason you may have been notified in your child's case is it does say under the department's testimony that generally a child care home or center will forward an incident report to parents unless advised otherwise. So while it's not in the law and these requirements are not in the law, I guess it's a general practice that they do. But not all of them, which is why I guess this is the bill is before you.
Right. And as Delegate Shetty mentioned, that was because her child may have been injured or something else on the playground. And I know that happens in most of the schools as well as child care providing situations. Does this raise any other questions or concerns?
Madam Chair.
Yes.
So I guess the frame, I guess, kind of bothers me because I feel like it should be kind of on par with the current other time frame. I guess my other question is, Lauren, you had mentioned that they are to notify the parents, I guess, when you're talking about Delegate Shetty's case, unless advised otherwise. And I guess I had in my notes kind of the question, in these situations, say they notify, the school superintendent, law enforcement, and law enforcement advises them not to disclose the information just yet for whatever reasons, because of their own investigatory processes that they have in place in these situations. I guess that's my concern. If they're being advised by law enforcement not to say anything, but then report to the parents, kind of what does that do? Is one of my questions. The other question I had, I noticed in the bill, it has an effective date of July 1st. And I don't know why that is as opposed to the regular effective date of October 1st. And so those are my questions and concerns that I had.
So Delegate Crutchfield, would you like me to answer?
Sure, go ahead, please.
Okay,
Thank you.
so to the first point, Delegate Williams, I'm not sure if I'm quite getting this, but on page 3, lines 16 through 19, the bill is contemplating what you've raised about prohibiting the notice if the local department or law enforcement agency advises that it would interfere with an ongoing investigation. And to the second point about the earlier effective date, that's sort of the legislator's choice if they feel that a bill requires, they would like the bill to take effect earlier because of maybe an exigent circumstance, or that's generally the reason. They just want it to take effect earlier because there's a concern that time is of the essence to stop further damage and something like that.
Well, it appears to me that there's really kind of a timing issue on this. Because even if we play out what Delegate Williams mentioned, so in reality, if you were to give a parent 24 hours notice, when have you provided notice to the authorities? And is it enough time between the notice to the authorities and possibly the notice to the parent for there to be some discussion with the authorities and for them to decide maybe it's not okay to send out the notice, or maybe there's something else that's compelling them to believe that maybe the notice is not necessary. The other concern I have also is that you have put people on notice, but there's really, and I don't know if it's really a formalized accusation against someone, or is it just knowledge? And with knowledge, usually people, I'm in the situation, if we currently look at it, you would just go off and contact the authorities would take over, they would do the investigation and determine whether there really was a child abuse situation. So I'm a little concerned about the timing of all of this and whether, someone is really accurately accused of something, because, once it's out in the public, once you contact parents, then parents are going to assume there's truly a situation, whereas maybe there isn't one, or maybe there's something else, or maybe a child expressed or presented a certain way, but in actuality, it didn't happen. So those would kind of be things that I would think about too in this scenario. Delegate Bartlett. Unmute.
Sorry.
Okay.
Delegate, Madam Chair, I just have a quick question.
Sure.
There was a request for an amendment. I don't see that has the bill been amended?
I don't think so. Lauren, do you know?
No, there haven't been any amendments submitted.
Okay, so the request was, and since we have the bill sponsor, I can probably ask directly to her, but the request was to make it for all child care type facilities, nothing carved out. And so I just wanted to know if that was something that is being worked on, or if you thought about it, or.
Yeah, that's totally fine with me. That's what I intended for it to be. So I'm not sure how the drafting didn't turn out like that, but yeah, that was the intention.
Okay. Delegate Atterbury, Vice Chair.
Thank you, Madam Chair. So my question is this scenario has been playing in my head. Is it likely that there's an investigation? I'm just looking over at the monitor at this information report. Is it likely that my child could be at the child care provider? An incident happens. For whatever reason, the police say, don't report it to me. And they're investigating. And they do determine something happened. My child is still going to that child care facility because I have no idea that this has taken place. So then when I find out, I don't know who's going to notify me at that point, the police or the child care facility, that this happened, like 14 days prior or 30 days prior, or if longer. I mean, is that a likely scenario? If that's a likely scenario, then I have a strong problem. And I would think we need to figure out how the parents can get notified. I don't know what it seems really vague in terms of, and I think Delegate Williams already mentioned this, a child care home or center will forward an incident report to parents unless advised otherwise. Like, what does that mean? And is that just open-ended? I mean, because I think any parent would want to know, if my child slipped and fell at recess and skinned their knee, I would want to know, let alone they were used by somebody who was there. And then I'm the person that keeps sending them to that school. I think that's just something we need to think about.
Can I respond, Madam Subcommittee Chair?
Yes, you may.
So that is the exact situation that this bill was written because of. A child was molested by another child that was significantly older at a daycare, and they did not tell the mother or the other potential victims for months. And I think only one of those cases was actually pursued by police. All of the other ones, they didn't have enough evidence for that. So that's exactly what this is seeking to address. Just if it's triggered that you must report it, if it's a mandatory reporting trigger, then you at least have to let the parents of the potential victims or witnesses know.
So Delegate Erican, how quickly did they report it to the authorities, or did they report it at all? I mean,
They did. They reported it, I think, within a few days. I'm not even sure if they may have violated the law and how long they waited there as well. They did their own investigation first, I believe. But yeah, to me, the second that it's serious enough that it needs to be reported to authorities, that's where the line is, where I think parents need to know too.
Okay. Delegate Shetty.
Thank you, Madam Chair, for another bite at the apple. So I wanted to respond a little bit also to the Vice Chair's great comments and offer some additional perspective. So I do believe that even the most well-intentioned schools, sometimes get embroiled in this concept of like personnel records and like protecting staff and personnel first, and even if there's a lack of clarity to some in like what and when things should be reported, because there are many issues that we hear before our committee that are not at all in a gray area. But there are some things that schools view as potentially like gray area, which is why some of the training bills that we've pushed have been so incredibly important to make sure that like all of these educators are accessing like training and know what they should be reporting and when. That said, I think that this is a really important bill because it does address a really serious issue of families not knowing when circumstances are happening, and could potentially address that exact situation that you're outlining, Madam Vice Chair, of, you're continuing to send your child not knowing that the school that you've trusted, has been, is viewing something more as like a personnel investigation, or they're cooperating with authorities, but they're not viewing like the families as part of that process. And I think that they should be. So I hear where people are coming from on like the conflict between the 24-hour notice and the 48-hour notice that's currently required. But if I were a parent in that scenario, particularly if I were the parent of a child who could be a victim, I'd want to make sure that I'm getting treatment for that child as soon as possible, if needed. Thank you.
Okay, and Delegate Bartlett?
Thank you, Madam Chair. Yes, I'm back for a second break because I didn't finish the my questions. I was too quick to close that window. So this is from the Maryland State Family Child Care Association's testimony. And there were, so the First Amendment was the one that I spoke of, that it should be for all children in child care and all facilities. Okay. And then the other thing that they wanted was they wanted to amend the word, they wanted to delete the word suspected because they said that if an incident or allegation of an incident is suspected, I don't know why I'm having trouble saying that word today, and proves to be untrue or is found to have no negligence, then it kind of taints it gives a permanent scar to the child care facility. So that was one thing that they were concerned about. And the last thing, or actually there's two more things. They wanted visual evidence to be required before mandatory reporting. I don't agree with that one. So let's just, I don't support that one. So, and then the last one was they wanted a specific form from the Maryland Department of Education that documents the incident, and it doesn't include obviously the names of the children unless the incident is substantiated. And in fact, you probably wouldn't want to include the names of the children anyway. But those were some other things. So I just wanted to kind of get more feel for that testimony because they did have some substantial amendments.
Well, let me kind of give you some thoughts too about that as well as we talk about this. I would say, again, as a parent, with a child that would be in that kind of situation, a child care provider, and I totally agree with Delegate Shetty that you want to have information as quickly as possible regarding the situation. I don't think having information that says it's not alleged or not sustained, or, I think the point is that as a parent that your child was in this situation, And I think in that notice, maybe that's part of where you put in there that, this is still under investigation, or this is under review, or this has been passed on to the particular authorities and they will take it from here, and this is who you need to contact. And so maybe that kind of eliminates, the notion of removing something. But I think, again, you want to know, that what's happening. Again, I just wonder about how much time, and I agree, it should be as soon as possible. So the question also is, what about the conflicting interests of them having to provide this information to the authorities within 48 hours? So the parents get it in 24, but then the authorities get it in 48. Now, as a parent, once we've gotten that information, we've probably now, taking it and said, oh my God, what's happening next? And you want to know immediately from authorities what they're doing, So I think that's part of the conflict too, is, what you do next, as a parent. And as far as the going forward with the daycare provider, I mean, there's not a whole lot you can do about what the public or anybody else is going to think about them once they've given the information. I just think that if there's a duty for them to do it, then that's a duty they have. And if for some reason there is some fallout from them providing it, that the public or whoever else, all the other children at the center, parents decide they want to remove their children, or there's some other scar regarding that, I think that they've just got to understand that that's a part of the business, and they've got children who are in their care and custody. I don't know how you get around that piece. Go ahead, Delegate.
I'm sorry, if I may. So with respect to the form, no necessity for the form, at least right now, right? We're going to leave that alone?
Unless we have amendments to do it.
Okay. And
the
then
form sounds good though.
The other thing is, and the 48-hour rule is not the minimum time. That's the maximum amount of time.
That is the maximum time.
Right. So they could very well contact the police within 24 hours. They can contact the police first, and then
we would hope so.
Yeah. And then contact the parents. So, I don't see a conflict there necessarily. I see, some perhaps maybe they would want to argue, well, we only have to do that within 48 hours. But yeah, I believe the parents need to know unless they are the suspect.
Well, even if I don't know what they do next, they should contact the police and then decide what to do next. But
yeah,
nonetheless, the parents are going to know. I mean, their children are there, or the child involved, and I'm not sure, and it's to all the parents and guardians of children at the provider's location. So it would have to go to everybody. Any other discussion on this? Questions? How does everybody feel about the bill? Delegate
I'm sorry, I just have one last question.
Yes.
I've actually had a situation like this when my children were young, and that's why I'm, kind of harping on it. Yeah, you definitely need to know. You definitely need to know early. But my question is, if the parent is the suspect, but I guess that's when the police come in and they will advise what to do. Okay, yeah.
Yeah, well, and you would hope, again, that the daycare provider would contact the authorities first, right? I mean, it's sort of like in tandem, contact the authorities, contact the parents, something where it's close in time for both.
Mm-hmm. Yeah,
I definitely
like contacting. I'm sorry, Madam Chair.
And then they could be advised on what to do. I mean, that's part of it, at least that's what I would hope.
Okay. Yeah, I definitely like contacting the parents. It's important. I just also know that it's fine. I like the bill, and I just want. Oh, I know what I was going to say. I just want to protect the children as well. If the parent is the suspect, that's the only thing. That's the only thing that concerns me. Just a teeny weeny bit, but I can live with it. I think we have other mechanisms in place that will help us. Like, for instance, will Madam Vice Chair's bill with the mandatory reporting, that one is if you suspect child abuse that we passed, I guess, what was it, last year or something? So that if a child came to school or came to the childcare and there seemed to be abuse that did not occur at the childcare, they would have to report it anyway, right? Okay. Thank you very much. That's where I was concerned. I'm fine now. Thank you for your indulgence, Madam Chair.
Thank you. Delegate Williams, you have a question?
Now that we have the bill sponsor here, I was just going to ask the question I asked previously about
Okay.
July 1st effective date and why the bill sponsor chose that date as opposed to just the standard kind of October 1st date. That was all.
We chose that because it was before a new school year was starting. And so we thought we wanted to be in effect to sort of capture the whole year. So there wouldn't be sort of a staggered start time.
Got it. Okay, thank you.
Okay. Any other, Vice Chair, please.
Thank you, Madam Chair. I would just say to the sponsor, I mean, childcare centers are open year round. So when you have little people, they don't get a summer break. They go to those childcare centers all the time. So earlier, but
If Vice Chair is interested in an amendment that makes an emergency bill, I'm all for it. Because to me, this is an emergency for real.
Okay. All right. So Delegate Erican, just really quickly, I mean, what did you have in mind? How do you think this should play out? Do you think the parents should be contacted first, the authorities? In your situation, I mean, what do you think is the best way that this should be done? Just curious.
So the intended language should have been within 24 hours of the mandatory reporting triggered. It wasn't really supposed to be 24 hours from the incident. So I'm not sure how the drafting ended up like that, but it should have been, if the daycare calls the authorities, they have 24 hours to follow up with on business days to follow up with the families to let them know what's happened in that child's classroom. So it wouldn't be every child unless there is a one classroom, but it'd be the children who are at risk of being exposed to the situation. So it wouldn't happen. They would not get to know before the police know, because the police are supposed to be advising them on how should they proceed, just in case they don't want to compromise some kind of case or something like that. They should at least get involved. So it would be sort of, once mandatory reporting is triggered, then they have to at least let parents know that something may have occurred, and that some children may benefit from some kind of therapy or somebody to talk to about it.
Okay, or that the investigation is ongoing and,
Exactly. Yeah, just let parents
take
know what's happening.
appropriate steps. Okay.
Yep.
So, so that sounds like amendments to me. Is that what you would like to do? Would you like
it's the will of the body, whatever you guys feel comfortable with. I mean, I think you guys understand the intent of the bill. So
Right.
I trust it. It's in your good hands. And if you think amendments work, I support whatever you guys decide.
May I interrupt, Delegate Erican? I'm reading your bill. It does look like the 24 hours is triggered from the report, the mandatory report.
Okay, excellent.
So,
Good.
It says within 24 hours after first having knowledge of a report required under 5-704 or 5-705.
Okay, perfect. Yeah, that's what we intended. Yeah, that's because I refiled a bill that was filed last year. So I was usually, it just ends up being the same bill, but I don't know. I thought maybe this time it got messed up somehow, but no, that's exactly what I intended for it to look like.
Okay. All right. Any other questions? How does everybody feel about the bill now that it's been explained a little bit more in detail to us? I don't see any questions. Any more questions or concerns?
Move favorable.
Second.
All right. Okay. And let's go ahead and by a raising of hands, let's go ahead and vote to move it favorably. So everyone in favor, let's raise our hands. Okay, I see Delegate, I'm gonna put mine down while I go through this. I see Delegate Bartlett, Vice Chair. I see Delegate Griffith, Delegate Shetty, Delegate Watson, Delegate Williams, Delegate Malone, Delegate Cham, Delegate Lopez, and myself. And that seems like that's unanimous. Is that correct, Lauren?
That's
Is
correct.
that it? All right. All right, well, thank you very much. It looks like we have voted this favorably out of the subcommittee. Appreciate everybody's time on this, and we are adjourned.
Thank you.
Thank you.